So, thank you to everybody who is joining us for this second half of our event on the future of these islands and the future of Ireland and British-Irish relations. We are delighted this evening to have Chief Justice Frank Clarke to give a keynote address on the future of the common law post-Brexit. And before we begin this event proper, we'd like to present him with the Gold Medal for outstanding contribution to discourse that the Society gives, particularly leading public intellectuals and individuals of great merit. And we're particularly awarding this medal for his leadership in promoting access to justice and his intellectual contribution to legal discourse. So I'd invite you to welcome him with a round of applause and welcome him with this award and medal. I now cede the floor to Sir Donnell Deeny to open this half of the evening's event. Thank you.
Chief Justice, Mr. President, Mr. Auditor, ladies and gentlemen of the Historical Society, ladies and gentlemen, it's a privilege to chair tonight's session of the week's events in honor of the Hist250 in this beautiful room, where I normally confer degrees from this dais, so this is a different role, and to do so in our alma mater, or the alma mater of those of us, Chief Justice, lucky enough to have attended Trinity College, which has been justly called the finest built space in Ireland. And without further ado, as we're starting slightly late, I want to call on Dr. Andrea Mulligan, Barrister at Law, Assistant Professor in the School of Law, and I'm happy to say a former Treasurer of the Society, to introduce the keynote speaker. Thank you.
Chief Justice, Sir Donnell, ladies and gentlemen of the College Historical Society, ladies and gentlemen, it's a real privilege to be here to be part of such a wonderful celebration, and especially to follow those brilliant student speakers. What absolute firebrands. I think we're all in good hands. As Sir Donnell said, I am a member of the faculty of the School of Law and a practicing barrister, and I can honestly say that in my professional life, I regularly call on the skills that I developed here at the Hist. So obviously that's things like critical analysis, oratory, but perhaps also, a flair for gossip and political intrigue, which one would hone very effectively over in the GMB. My role this evening is to provide some introductory remarks before I hand over to our keynote from the Chief Justice. And we just heard two brilliant political panels on the future of these islands. And whatever your perspective or your wishes for the future of these islands, there's no doubt we're facing kind of an exciting political moment in the evolution of these islands. The questions that we talked about in the panels earlier on, things like the UK's departure from the EU and the novel status of Northern Ireland, the future relationship between the North and the South and the possibility of unity even in the distant future, and all of that against what looks like a sea change in politics south of the border. They're all political questions. And in the panel discussion, you heard great political analysis of those questions. But as a lawyer, I suppose I'm here to remind you that for each political question, there's an equally complex legal question bound very closely up with it. So if we take, for example, Northern Ireland, it's a wholly novel question of European law, whereby Northern Ireland will to some extent remain governed by European law, but not represented at a legislative level in the making of European law. And a very unusual relationship with the Court of Justice into the future. Similarly, discussions of Irish unity are fundamentally questions of constitutional law, engaging very complex technical constitutional questions, as Katie referred to earlier on. So what I'm saying is, if you're interested in the political questions, you are necessarily also interested in the legal questions. If you like the politics, trust me, you'll love the law. It's even more interesting. And at this point in the evening, I suppose we turn from the political to what is definitely a legal question. the future of the common law in Europe after Brexit. But don't be disheartened. First, it's a very interesting legal question, and I'll say a bit more about that in a moment. Second, and perhaps more importantly, we should recognise that in this country we have a very rich and strong tradition of public and popular engagement with complex legal questions. And that's best demonstrated, I think, through our tradition of constitutional referendums. We are unusual in that we have a written constitution, but we change it pretty regularly. And every time we have a constitutional referendum, we deeply engage with complex legal questions. We see the Irish people learn all about those questions seriously, carefully, talk to their friends, talk to their families. And it's a tradition and a feature of Irish public life of which I think we should be extremely proud. We're one of few European countries where we have to have a constitutional referendum where the treaties change. And as a result, we have a tangible sense of popular sovereignty in our dealings with the European Union, and in fact we take it so seriously that we're quite reluctant to give it away. We rejected both the Lisbon and the Nice treaties on the first time round, and they had to be rerun. And in fact, perhaps those two referendums provide the best example of Irish people having to engage with complex, often rather dry legal questions, which would flummox many practicing lawyers. The good news is that the legal question we're dealing with tonight is a lot more interesting than the Lisbon and the Nice referendums, and a lot more accessible. The Chief Justice will explain more about why that's such an interesting legal question, but let me do some very basic groundwork. In the European Union, there are two different kinds of legal system, common law and the civil law. The common law here, as elsewhere, is a product of British rule, although since 1922 we have developed our own distinctive Irish common law. Every other system within the EU, aside from that of the UK and Ireland, and I don't include Scotland here in the UK, is at least partly a civil law system. So the European Union, in creating one unified legal system, had to marry those systems to some extent. And it hasn't always been the happiest of marriages. But from our perspective, and luckily for us, in terms of defending our common law view of things and imposing our common law view of things, we always had the bigger, richer, bolshier United Kingdom to do a lot of the fighting for us. And in a post-Brexit world, we find ourselves alone without Mother England by our side. And unusually, as a former colony, may find ourselves the people championing the common law in Europe going forward. So it's undoubtedly a complex legal question, and there's no better person to show us how to engage with such a complex legal question than the Chief Justice, our keynote speaker tonight. The Chief Justice assumed his position in July 2017, and his tenure has been marked by a commitment to access to justice and to demystifying justice and the court system for ordinary people. He was the first Chief Justice to oversee live television broadcasts from the Supreme Court. He also spearheaded the practice of bringing the Supreme Court to hold sittings outside of Dublin, a shocking reminder to Dubliners like myself that Dublin is not the centre of the universe. This commitment to demystification will be no surprise to anyone who is familiar with the Chief Justice's judgments, and any lawyer might be familiar with the experience of trying to get to grips with a really tricky area of law and the joy of finding a judgment from the Chief Justice that explains precisely what the law is and where the law is going in clear, accessible terms. So for that reason, I'm very pleased to introduce to you tonight our keynote speaker, Chief Justice Frank Clarke.
Thank you. I'll try and live up to the promise of explaining things in clear terms and avoid the complaint made by the last student speaker that lawyers and judges tend to express things in ways that no one else can understand. It might be said that that suits lawyers, because if no one else can understand it, then you have to pay lawyers to explain it to the court, and if the court keeps it that way, everyone is happy. But I do believe that it is important that there is public engagement with these issues. And I also thank the College Historical Society for being so inclusive as to invite a former LNH person to come and speak to you on such an auspicious occasion. In fact, the last time I formally spoke at the Hist, I was captaining a UCD LNH team in a colours debate in 1973 when the opposing Trinity Hist team was captained by one David O'Sullivan, whom I note on the programme is chairing one of the sessions tomorrow. So a long time passes, but nothing much changes. But to return to the topic of tonight's debate, I suspect that most of you will, in a very vague sense, know that one of the categorizations of the legal systems of the world is between the common law system, which we operate, and the civil law system, which operates principally in continental Europe. And as we know, the common law developed over centuries in Britain and was spread to many other parts of the world which have British contact. Indeed, one historical writer described Ireland as the first experiment of the export of the common law, going back perhaps 5 centuries. The civil law developed in continental Europe with models such as the Code Napoleon, and has also itself spread to other parts of the world. And while perhaps many know of the difference between the two systems, I suspect that apart from practitioners who've had occasion to have to deal with the matter, or those who've studied comparative law, many will have little knowledge of the real differences between the two systems. In truth, a whole series of lectures, let alone a single address, will be needed to explore those differences in detail. But I think to understand both the challenges and the opportunities which Brexit poses to the common law, and particularly the common law in Ireland, I think we need to start with at least a basic understanding of those differences. From my perspective, perhaps the greatest single distinction in practical terms between the two systems stems from the very different ways in which litigation, both civil and criminal, is conducted. At its most basic, I think it's reasonable to say that in the common law world, litigation is very much party-led. It's the parties who procure and present evidence. It's the parties who are required to research any legal issues and present the court with whatever legal materials, legislation, case law and the like may be necessary. And in passing, I think it's worth observing, not least in the context of the very fine access to justice points made by the last student speaker, Leanne Brosnan, that system works well when parties are represented by competent lawyers, because the ability of the inexperienced or the untrained to procure and present appropriate evidence and research the law is necessarily limited. And we are increasingly facing problems, I think, in many common law jurisdictions, that the court is faced with many unrepresented parties, which makes that party-led system all the harder to work. But be that as it may, the role of the judge in the common law system is simply to consider the evidence presented, if necessary to determine any legal issues based largely on materials put forward by the parties, and come to whatever is considered to be a just conclusion on the evidence and the law. However, in civil law systems, the judge's role is more central. In criminal cases, for example, many civil law systems have a judge, often referred to as an examining magistrate, who investigates the case to determine whether there's a sufficient basis for a full trial. And in both civil and criminal cases, while the parties are entitled to be represented, the judge plays a much more central role in the presentation of the evidence and in conducting the necessary research on the law. I know from recent contacts with many senior courts throughout the European Union that most of them, even with countries of similar size or even smaller than us, have very large research departments, or young trainee judges who are making their way through the system, who may act as referendars or assistants to more senior judges. Our system is almost entirely based on what happens in the courtroom with the assistance of lawyers. There are also very significant differences between the underlying approach to the law itself. In my view, in one sense, those differences are perhaps a little greater in theory than they are in practice, but they're nonetheless real. In those areas covered by the common law, decisions of higher courts as to what the law can, in the absence of legislation, it can represent the law itself. There is no other basis for the law other than the case law. The law is what the case law says it is. It has no higher justification. While lawyers in a civil law system would speak of the jurisprudence of the courts in a particular area, civil law systems don't have principles similar to those that apply in the common law for giving legally binding status to the decisions of higher courts and strict rules about when that case law can be changed. Rather, the underlying basis for or theory behind law in a civil law jurisdiction must be found in some normative legal document, a constitution, a Bill of Rights, legislation, or secondary legislation like bylaws. There may be established case law or jurisprudence about how those written documents are to be interpreted or how their provisions are to be applied in particular types of cases. But that case law is simply seen as deriving from the underlying laws adopted by parliaments and the like. And in one sense, to use the computer term, it can be said that the common law does permit the law to be picked up by its own bootstraps. The civil law does not. At that very theoretical level, there is a very wide gulf indeed between the two systems. But in the real world, legal systems have to grapple with a whole range of problems, and I suppose it's hardly surprising that they frequently come up with at least similar solutions to the same problems. One overarching issue which every legal system has to confront on a very regular basis are the competing demands of consistency and flexibility. Courts may legitimately be criticised if similar cases are decided in very different ways. On the other hand, it has to be acknowledged that an overly rigid approach can create more rather than less injustice. And finding appropriate ways to marry consistency with an acceptable level of flexibility is, in my view, one of the great tasks with which any legal system is likely to be confronted. In that context, I was very struck by a discussion which took place at a meeting a few years ago between our Supreme Court in Ireland and the German Constitutional Court, the Bundesverfassungsgericht. Our German colleagues were interested in whether the Old English system of stare decisis, which was the Latin term, and I do myself try and avoid Latin terms where possible, but it's the Latin term by which a legal point decided by the highest court may be taken to have been decided forever. They wanted to know, did we apply that still in Ireland? And I think the Irish answer was that we did to an extent, so that, for example, lower courts are bound by the interpretation of the law given by the Supreme Court. But I think we also acknowledged that the Irish courts, like the courts in many common law countries, have developed ways and means by which the case law can evolve or deal with new situations, or in situations where the courts considered, frankly, that the previous decisions were just plain wrong. Furthermore, there's an awful lot of debate goes on in litigation about distinguishing one type of situation from another, and thus determining that the underlying principles may be applied in a different way because the circumstances are different. In other words, stare decisis might imply absolute consistency with no flexibility. However, in practice, our courts have developed techniques and ways and means for the introduction of a degree of flexibility into what might otherwise appear to be a very rigid system. But in turn, the Irish asked our German colleagues about how they managed to achieve consistency where there was no binding effect of the decisions of the higher courts other than binding the facts of the individual case. But then our German colleagues indicated that they wouldn't likely depart from an approach established in their case law, so they would need very good reason to change from an established approach to a particular means of legal application. And indeed, I'm aware that in many continental countries where the superior courts, equivalents of the Supreme Court, often have a very large number of judges dealing with different types of cases. Many of those courts have special procedures, plenary sessions, larger panels of judges or whatever, to deal with situations where there may be inconsistent decisions between different panels. Therefore, in practice, while the civil law does not recognise the sort of binding effect which the common law attributes to decisions in our system, techniques have been developed in civil law countries to ensure consistency within what might, in theory, be considered to be a very flexible regime. And that dialogue, I think, perhaps teaches us that while the systems may be at polar opposites in theory, they can be an awful lot closer in practice. And I think our German colleagues came to much the same conclusion. But finally, before going on to the European dimension, which is at the heart of tonight's topic, it's worth saying that many areas of the law in Ireland today are in fact governed in any event by legislation rather than case law. Company law, for example, is more or less completely codified, so that the case law simply involves the interpretation of that legislation and decisions about how it should be applied in particular circumstances. While there are some areas of criminal law which remain entirely based on established case law, much of that area is now governed by legislation, with the case law representing, again, simply the interpretation of that case law rather than a freestanding source of the law itself. And indeed, when we come to the European dimension, it's worth noting that there are two smaller jurisdictions which have a mixed system, partly common law, partly civil law. They are Cyprus and Malta. And we're small, but they're very small by any standards. We're, I think, 5 times bigger than Cyprus and about 20 times bigger than Malta. But in any event, the Cypriot Criminal Code is now a codified document, but it is based on common law principles. So they took the case law of the old common law and put it into a statutory form, as it were. Malta, curiously, it's a funny coincidence, well, perhaps not coincidence, but oddity, that in Cyprus, the private law is based on the common law, but public law, judicial review and the like, is based on the civil law. Malta is the other way around. I think it may stem from the particular parts of their history when they were under British control, but we have that curious situation that our two remaining partly common law jurisdictions within the EU have that mix, but an opposite-sided mix. And as an aside, I should say that I have proposed and had accepted by the Chief Justices of both Cyprus and Malta that we are to form a network of common law court presidents precisely for the purpose of attempting to promote the position of the common law within Europe. And the first meeting of that body will, for reasons which I will tell people over a glass of wine later, is going to take place in Riga later this month. Latvia is not a common law country, I just want to be clear. So the real Brexit-related question which you now face is in that context, where we are the big one, for what it's worth, and the other two are very small, is how the common law has coexisted within the European Union and the challenges with which Ireland will now be faced in circumstances where we will become, where we will be the biggest country, and where, as was pointed out earlier, that party whom we were able to rely on to some extent, the United Kingdom, has departed. It would be possible, I think, to have a very interesting theoretical debate about the extent to which the common law itself influenced the development of European Union law. The Court of Justice of the European Union is given under the treaties the role of being the definitive interpreter of all issues of union law. And in that sense, the decisions of the Court of Justice on questions of union law are binding on all of the courts of member states. And while the Court of Justice itself doesn't operate a system similar to stare decisis, it regularly refers to legal problems having been determined by what it calls its settled case law. So that's not entirely dissimilar to a common law approach. And likewise, while that case law may be seen at one level to simply involve the interpretation of the treaties or European legislation, there are aspects of European Union law as it has developed, and in the case law of the Court of Justice, which have really only a very tangential relationship with any written legal document. And I might give a recent example of a case which was referred by the Irish Supreme Court to the Court of Justice as an explanation. The actual case probably isn't that interesting except to those who were involved, in that it was a tax case. Most ordinary lawyers' eyes glaze over when they get involved with revenue law. It's only people who might have to pay tax or revenue officials who have a deep interest in that area, though it can be quite lucrative for the practitioners, I should say. But the question was whether the Irish Revenue Commissioners were entitled to recharacterise a set of transactions in what might be described as a tax avoidance scheme, so as to make the taxpayers have to pay the amount of tax that would have been due had that tax avoidance scheme not been adopted. And at the relevant time when these transactions happened, though things have changed since, there was no specific Irish legislation which would have allowed the Revenue Commissioners to do that. And likewise, there was no specific measure of the legislation of the European Union which would authorise that course of action. However, the Court of Justice, applying a principle, or what's called a principle of European Union law, which is sometimes referred to as the Abuse Doctrine, the Court held that the Irish Revenue was entitled to adopt that course of action, even though the transactions in question had taken place before even the Court of Justice had given its first opinion on the applicability of the Abuse Doctrine in tax law. So it was almost retrospective in that sense. Under the Abuse Doctrine, the Court of Justice in a number of areas has held that it's open to courts in member states to take action to ensure that there's no abuse of European Union legal measures, and in the particular context of VAT, which is what was at issue in this case, that national authorities were entitled to levy VAT as if the abuse and aggressive tax avoidance measures had not been adopted. And that was so even though the measures would technically have worked within the letter of the law. And we wouldn't find any specific provision in the treaties, union legislation, or that makes any reference to that doctrine. It is said by the Court of Justice to represent a fundamental principle of union law. And I want to make clear I have no quibble at all with the doctrine, but it does seem to me that it's very close to a common law type situation where really the only source of that law is the case law itself. It doesn't derive from any normative substantive law. This is again an area where we could have a lengthy debate with legitimate points being made on all sides. But I think, to get down to the business end of the debate, I think it has to be acknowledged, as was said earlier, that the United Kingdom, having been a significant player within the European Union, has made a material difference on the development of European Union law, even though we might have a legitimate debate about the extent of those differences. But there is another way in which I think the impact of union law on the common law world has the potential to give rise to difficulties. Precisely because of the significant differences between the two systems, the crafting of European Union legislation in a manner that fits neatly into both systems can sometimes be difficult. Because of that, the risk of unintended consequences will always be there. And the presence, therefore, at the table, whether it's the negotiating table at which the content of legislation is thrashed out, or Council's table in the Court of Justice where arguments are put forward, the presence of a common law voice at that table seems to me to be particularly important to minimise the risk of union legislation causing unanticipated problems when transposed into the law of a common law jurisdiction. And with that in mind, it's perhaps important to emphasise one significant aspect of the legal system of the European Union, which is in significant contrast to the equivalent system in a federal country such as the United States. In the US, each state has its own law, but federal institutions, Congress and the President, also enact federal law. But there are entirely separate streams of courts to deal with cases under respectively state law and federal law. For example, if the parties to a contract entered into New York have a dispute, then they go to the New York state courts. If someone is alleged to be guilty of a crime under New York state law, they're charged before New York courts. But if there are issues of federal law involved, whether civil or criminal, then the case goes directly to the federal courts. So there's two entirely separate streams of courts. And for federal purposes, the US is divided into a series of districts. One such district, for example, is the Southern District of New York, which includes Manhattan and therefore Wall Street. And that district court will hear any federal cases involving financial issues arising out of Wall Street. And there are separate federal judges sitting in New York to hear those cases, and provision for appeals to the Court of Appeals and the Supreme Court if necessary, which are of course themselves federal courts. But the system in Europe is entirely different. There's no European local court sitting in Dublin or Belfast or London or Berlin or anywhere else. The ordinary Irish courts or UK courts or German courts are used to hearing cases properly arising within their state, whether those cases involve national law, European law, or a mixture of both. Every day, Irish courts regularly apply European Union law to decide cases, some of which are governed entirely by that law. So that's a radical difference between the two systems, where national courts are truly European courts, in a sense that New York courts are not US federal courts. But as part of that system, and perhaps many would think an important part, European Union law recognises what is sometimes called the procedural autonomy of each member state. That means that, subject to some limitations, which are there to ensure that national procedures have to be effective to protect European Union law rights and cannot discriminate against European Union law cases, it's left to a very large extent up to each member state to establish the structure of its own courts, the procedures that they follow, even where those courts are applying European Union law. And that principle applies unless there is some specific measure of European Union law that requires some particular procedure to be followed. And there are some of those, and perhaps an increasing number of them, but they're still relatively few in number. But as I suggested earlier, the court process in a common law country is very different from the court process in a civil law country. And quite considerable difficulties have been encountered on occasion in attempting to adapt the procedures in a common law jurisdiction to certain types of European legislation. And I suspect those difficulties will continue and may even increase. Many examples could be given, but I'll touch on just one. European consumer law requires a judge hearing a case which comes within certain definitions of consumer contracts to consider of that, as lawyers would say, of that judge's own motion, i.e. not as a result of any argument put up by the parties, but because the judge has to do it him or herself, whether the terms of that contract are fair. Now, that's a process that's perhaps not unusual in many civil law countries, but it's quite different to what traditionally judges in a common law country have done. And most of our court structures and procedures haven't really developed with the view to judges exercising that kind of role. And there have been some difficulties with judges themselves adapting to carrying out that role, because judges are used to doing it in the way that, well, no one made that point, so I don't have to decide it. Well, European law says you do, but that means, for example, the judge may have to go and research the point themselves, read the contract themselves, consider whether that would amount to an unfair contract term as European law would define it. And that's again a role which judges are not used to playing, but also, importantly, a role for which judges don't have the backup to assist them in carrying out. So I think fitting European Union measures into a common law system can sometimes be difficult. And I think one of the real challenges for the common law in Ireland post-Brexit is that the large voice of the UK at European legislative and judicial tables will no longer be there. Putting forward the case for tweaking measures to make it easier for them to fit into a common law system is a role which will now largely fall on Ireland, although we will doubtless have some support from our colleagues in Cyprus and Malta. And those challenges do, I think, pose a problem or a risk for the common law in Ireland. I personally don't perceive that there's any widespread demand within the European Union or its institutions to attempt to change the legal system in Ireland against our will. On the contrary, I know that many senior judges and officials dealing with legal issues in the Union have had some training, often at postgrad level, in the common law world, most particularly the UK and the US. And there's also, I think, a wide recognition that the European Union does a lot of business, both commercial business but also personal contact, with common law states. So the legal system of the European Union will need to interact with the common law world in any event. My greater concern is that measures adopted by the Union may have unintended consequences, which will potentially make it more difficult to maintain a common law system in Ireland by accident rather than by design. Now, these are not insurmountable problems, but the maintenance of a common law system in Ireland, assuming that's what we want to do, and I'll come back to that in a moment, will require significant vigilance. It will require greater resources being put into discussions at a European level on proposed legislation. For example, it's my understanding that there have been many cases in the past where, having discussed matters with our UK colleagues, Ireland has been content to allow any common law issues to be principally addressed by officials from the United Kingdom, unless there is a specific Irish angle to the problem. And I think it's probably fair to say that Ireland has, as in many other areas, been more active than our size might suggest, but nonetheless has had the advantage of being able to rely on the UK, where our interests in ensuring that European measures are compatible with the common law system are the same as the UK. Similar questions may well arise in relation to the need for Ireland to intervene more often in proceedings before the Court of Justice, where there may be a common law angle to be addressed. It cannot be assumed that such issues will be considered unless there's someone there to raise them, and I know the Irish Attorney General feels that it's likely that there will have to be more intervention by us to make, as it were, common law points before the European Court. And in addition, much closer to my own current role, it seems to me that the Irish judiciary will need to further expand our participation in the various bodies which represent European apex courts and the European judiciary. Such bodies are frequently consulted by the Commission. Their views often carry significant weight, and if we don't have a significant common law voice at those judicial tables, then any common law perspective may be missing from the views expressed by those judicial bodies to the European authorities, and consequently may not be reflected in whatever measures emerge. A final point on the challenges. The European treaties now give specific recognition to what's called the principle of subsidiarity. Under that principle, the intention is that where possible, decisions on what the law should be taken at national level, unless it's necessary in order to secure the objectives of the treaties, that measures be adopted at European level. It's an interesting fact that as yet no measure of European Union law has been struck down by the Court of Justice on the basis that it breached the principle of subsidiarity. However, it does seem to me that that principle gives a strong argument for suggesting that measures which impact on each member state's own legal system should only be adopted where those measures are truly necessary for the purposes of treaty objectives. Our common law system should not therefore be altered beyond any measures which are considered to be required on that basis. Now, that obviously does beg the question to which I recently referred about whether we ourselves might want to bring about a change in our own system. I'd emphasise that what I'm about to say shouldn't be taken as implying that I do not consider that significant reform is needed in our system. Indeed, I think it's fair to say it's been a constant, even repetitive refrain of mine in recent years. What I'm talking about here is not reform of our system, but rather changing it to a civil law model. Can I suggest at least two very important reasons why this might not be really a very good idea? The first is simply cost to the taxpayer. I've commented frequently in the past that all of the international data shows that the number of judges and support staff, and therefore courtrooms and court offices, are significantly higher in civil law countries than they are in those of a common law system. And I think this largely stems from the difference I referred to earlier between the two systems and the extent to which one is party-led and the other is judge-led. It would require very detailed research to make an accurate estimate of that extra cost, the cost that it would be to the Irish taxpayer of adopting a civil law system. But there's certainly a basis for considering that it could be as much as €500 million a year. Certainly if we compare, for example, the fact that even allowing for the difference in population, Germany would, if it had an Irish population but the same number of judges per head, have approximately 2,200 judges. Ireland would have, 2,200 judges if we had the same proportion of judges to population as they have in Germany. We have 168. You don't need to be very good at mathematics to realise that having that many judges and their support staff and courts would cost just a tad more than our system costs at the moment. And therefore, the amount of Irish GDP per head, for example, that's spent on our court system is less than a third of almost all European countries, and is less than perhaps a fifth of some of those who spend the highest proportion of GDP. So if we want a civil law system, we can certainly have it, but the taxpayer is going to have to pay. And I think perhaps that there's actually a moral in this. The parties to litigation in Ireland do pay more. It's dearer to run a court case in Ireland than it is in Germany, for example, often a lot dearer, and it is in the UK as well. But it's really a cost transference in my view. The work has to be done. It's either done by the parties or it's done by the court. If it's done by the court, the taxpayer has to pay it. If it's done by the parties have to pay it. I've used this as in my view, a strong argument for a much enhanced system of legal aid, because it seems to me that if the taxpayer is not having to pay out that extra half a billion euro a year, there's a good case that some of that might be used to provide support for people on whom the burden is placed of a party-led system who can't afford it. If it's the commercial court and the people battling are large multinationals, I don't think anyone's going to be too worried about them having to bear the cost of that litigation themselves. But where it's people who can't afford access to justice because we run our system and the taxpayer is saving a lot of money by running that system, I think that's a powerful argument for more legal aid. But that's an argument for another day. But there is another reason, I think, for considering that the maintenance of a common law system is important from a purely self-interested point of view, from an Irish perspective. Because as well as the challenges which I've sought to identify, it seems to me there are potential opportunities for Ireland in a post-Brexit world. Parties to international legal disputes can frequently exercise some significant degree of choice over the jurisdiction in which they litigate or engage in some other form of dispute resolution. There are a range of factors which may influence that choice. There can be little doubt but that London has developed a very significant reputation as a centre for such dispute resolution. And there are undoubtedly very many factors which have influenced those developments. The English courts have a very high reputation both for competence and independence, such that, for example, very wealthy Russian oligarchs have chosen to litigate their disputes in the London courts rather than the courts in Moscow. I just wonder why they made that choice. Likewise, there's a wide pool of very experienced and competent lawyers available in London, and similar considerations apply to other forms of dispute resolution, such as arbitration or mediation. But I think at least a material factor in the growth and continuing growth, at least to date, of London as a centre for international dispute resolution has been the fact that it is a major common law jurisdiction, English-speaking, and until now, part of the European Union. There are many union laws designed to facilitate and regulate the recognition of the decisions of courts of one jurisdiction throughout the other member states. These measures are seen as part of the necessary infrastructure of the single market. If it was very hard for a German company who'd successfully brought proceedings, for example, in Germany against an Irish exporter, to have that court order enforced in Ireland, then that would mitigate against the single market because it would make it more difficult or less attractive for that German company to do business with the Irish company. If you have a readily transportable court order from Berlin to Dublin, well then that enhances the single market. But each of those European Union measures is, of course, a matter of European Union law and is subject to the ultimate jurisdiction of the Court of Justice. And I think we all know that one of the brightest of the red lines adopted by the United Kingdom has been a desire to be free of the binding effect of the Court of Justice. And it will, of course, be possible that arrangements might be negotiated between the EU 27 and the UK, which will facilitate some degree of mutual recognition of court processes. I think that's not as easy as it might be seen or might be thought to be if the jurisdiction of the Court of Justice is not going to be recognised. And similarly, it's of course the case that all countries have their own rules for recognising the judgments of foreign courts long before there ever was a European Economic Community, let alone its successors. We have rules for deciding whether we recognise US decisions or Brazilian decisions, and so do all countries. So I'm not therefore suggesting that the orders of English courts will simply be ignored post-Brexit, but the important streamlining measures which exist in European Union law, which make the recognition of the orders of courts across the Union much more straightforward, will be most unlikely to continue to apply so far as the UK is concerned. And it's perhaps an interesting, chilling in some ways, anecdote to say that on the 3 occasions when there was potentially a cliff edge, where if 11 o'clock one evening, which is of course 12 o'clock Central European time, were to arrive without a departure deal on the part of the UK, and the UK had left without a deal, the so-called no-deal Brexit, a whole range of potentially very difficult legal consequences would have arisen at 1 minute past 11. Let me just give you a couple of examples. We don't have extradition with the UK. We haven't had it for a long time because there is a thing called the European Arrest Warrant, which is a simplified procedure for the surrender of people wanted in one jurisdiction to another. And at any given time, you take the snapshot, there will be a range of people in prison in Ireland awaiting the process of a decision as to whether they're to be surrendered from the UK. Imagine 1 minute past 11, on a no-deal Brexit moment, the nice man who's awaiting a consideration of his surrender to the UK goes to the prison governor and says, what's the legal basis for me being in continued custody now? And the governor says, oh, here's the European arrest warrant, that says it's okay. And he says, well, it isn't anymore because the UK's gone. So prima facie, that guy would have to be released. Now, emergency legislation was passed in the South, in the Republic's Parliament, the Donnell, I should call it, which, I've tried to use simple language, which allowed for us to go back to, on an emergency basis, extradition systems. But it would have required a court order to say, well, Mr. Mann, you're not any longer being held under a European arrest warrant, you're now being held under an extradition warrant. And the President of the High Court had arranged for a number of High Court judges to sit at 11 o'clock on those nights in case those emergency applications had to be made. As Michael Caine would have said, not a lot of people know that, but it was in fact, the plans were there because they had to be there. And perhaps another slightly sadder situation is that we have procedures for dealing with very troubled children who need to be in some form of quasi-custodial care because of the difficult situations which they have. And there was a whole series of cases some years ago where the Irish courts put pressure on the government to build specially designed facilities for such children. But there are some children whose problems are such that they are very unique and where we don't have the facilities to deal with them. And in some such cases, the Irish courts, using European legislation, had placed those children in institutions in the UK, sometimes in England, sometimes in Scotland. And I think there may also have been one case the other way around where the courts in Northern Ireland had placed a child in an institution in the south because we had a facility that was suited to that child's needs. But again, there has to be a legal basis. If someone is there ostensibly against their will, or if at least that you have a legal basis for saying you can't walk out the door if the person asks, that too could have disappeared at 11 o'clock on Brexit night. So there were a whole range of difficulties arising out of the interaction between union law and our laws. But of course, to go back to the opportunities which we have, it seems to me that the fact that Ireland will remain a common law country when the transition period expires on the 31st of December next. And we will retain, therefore, all of those mutual recognition and regulation procedures. We'll continue to be a common law country and substantially an English-speaking country, and therefore have the benefit of what I think can fairly be described as using the international language of business. Now, this does not mean, I think, by any manner, that the very many international parties who've litigated their cases in London will suddenly be wending their way to the forecourts or to arbitration rooms in central Dublin. But it does give us an opportunity to attract some of that business. In that context, I think it's very interesting that the government has approved the establishment of a programme in conjunction with the IDA and the practising professions called Ireland for Law. It's a kind of a sister of Ireland for Finance. And this project is designed to promote Ireland as a place for the conduct of international legal business post-Brexit, and the government has recently nominated former Taoiseach John Bruton to be the chair of this body. But our continuance as a common law country, with, as it were, a foot in both camps, being part of the common law world, but also part of the EU, seems to me to be vital to that cause. The fact that there may be work to be won from London, I think, can be seen from the establishment of courts in other traditionally civil law countries, designed to attract some of that litigation to their shores. The Netherlands has established courts which will now apply the common law. The Commercial Court in Paris, now, to everyone's great surprise, permits certain types of proceedings to be conducted in English. The fact that the French are prepared to allow litigation to be conducted in their courts in English shows that there's a prize to be won. These measures, I think, demonstrate that there are opportunities out there, or at least others apart from us think that there are opportunities out there worth pursuing, but it also demonstrates that we will have competitors. But we do, in my view, have real advantages. We are a common law country. We don't have to learn how to apply the common law. It's part of the nature of all Irish lawyers. It's what they grow up with from the time they get their first lecture as a freshman in a university law school. We can provide international parties from other common law countries, such as the US, with the possibility of litigating within the EU, but in the context of a legal system with which they are familiar. The US corporation that wants to litigate within the EU can do so in Ireland through a legal system which is very similar to the one which applies in its own state or federal courts. Some of our competitors have been heard, I believe, to argue that we don't really have the capacity to take on any work which might decide it wants to leave London. And we obviously are small, and there are limits to what we can do, while maintaining the quality of our courts, at least insofar as they deal with the kind of cases that might be attracted here. But I think it is fair to say that we have been successful in recent years in attracting many new, very high-quality members of the Irish judiciary. And if you speak to the judges of the European Court, they will confirm that Irish counsel are among the best that appear before them. There are obvious limits to the extent to which we can expand. But in my view, provided appropriate government resources are forthcoming, and the establishment of that programme seems to me to suggest that they may, we can certainly hope to attract some work from London. And this isn't in the written paper because I wouldn't like the government to hear this, so no one is to tell them. But from my cynical perspective, I have found in recent times that if you asked for something 2 years ago because you said we need this for access to justice, you'd be told about the trolley crisis, the education crisis, the housing crisis, and you're a long way down the queue. If you now go and say, I need to do exactly the same thing because there's a Brexit issue, you said, was that enough for you? Would you not like some more? So I'm hopeful that we may be able to piggyback some other issues on top of the Brexit-related push to attract more commercial work to Ireland. Clearly, the commercial work in itself will not improve access to justice except for large corporations, and I don't think any of us are too worried about that. But there may be spin-off benefits in terms of the resourcing of the courts, which may be of a much wider benefit to us all. In my view, it's obvious that we must recognise that London will continue to remain a very significant centre for international dispute resolution for the foreseeable future. Its expertise will not disappear, and many of the reasons why people have chosen London in the past will continue. But it does seem likely that there will be some reasonable movement away from London, and even a very small element of London's work coming to Dublin could be quite significant for us. Estimates of the value of such international legal work to London vary, but are frequently placed in billions of pounds sterling per year rather than even hundreds of millions. And even a small proportion of that would be significantly beneficial to Ireland. When I started talking about this subject some 2 years ago, I probably would, as it turns out wrongly, have been quite confident that we would by now have had answers to the key questions of the precise legal relationship between the UK and the EU 27 post-Brexit. But unfortunately, as we all know, that is not the case. And the current indications are towards difficult negotiations and potentially a looser set of relationships than might have been considered likely at an earlier stage in this process. And that seems to me to lead to the increasing possibility that the legal relationships between the EU 27 and the UK will become materially less integrated than perhaps we might even have thought in the immediate aftermath of Brexit. If that happens, I think it strengthens the case for there being opportunities for a common law country which may be able to offer dispute resolution within the European Union and which may prove more attractive, at least in some circumstances, than a UK which may have moved quite a distance away from the EU legal order. If that is so, then Ireland has at least a realistic chance of being a significant beneficiary. So the terms on which the UK will finally disentangle itself from the EU remain unclear, not least in the area of legal integration. There will undoubtedly be significant challenges in maintaining our common law system when we, with only slightly over 1% of the population of the Union, will be the largest common law country remaining in that Union. But there will also be opportunities which, I think if we play our cards right, may strengthen our position within both the common law world and as a state which punches above its weight in the Union. Hopefully it is those opportunities rather than the challenges which will prevail. Thank you very much.
Ladies and gentlemen, it's a great privilege to respond to the learned discourse that we've just heard from the Chief Justice. I have heard it and lucky enough to read the draft with interest and enjoyment, mixed with a touch of sadness at we're discussing the topic at all, because as you will probably all know, the majority of people in Northern Ireland voted against Brexit. But to use the language of an appellate judge, I'm happy to concur with Frank's remarks in their entirety and without criticism. I will just briefly mention two matters that arise under this topic of the future of the common law post-Brexit, which is obviously open, as this society is and this university is, to a wider world than just the jurisdiction in which we're sitting. Firstly, in recent years, the United Kingdom judiciary has referred to and relied on a European concept that hadn't existed previously in the common law, that of proportionality. And I think Frank had some knowledge of this as counsel himself, and it's a useful concept. It's not all that novel because it's not a million miles away from our old friend common sense. And common sense was what Lord Diplock, relative of one of the people here in the hall, what Lord Diplock said in the DPP and Hester was the mother of the common law. But proportionality was brought beyond common sense to some degree. The latter concept was referred to by Orphy Houston, I hope is a name still resonant in this university, ex-auditor of this society, Regius Professor of Laws, author of Salmon and Houston, and one of his several marvellous books is his Lives of the Lord Chancellors. And he spoke about Lord Halsbury. He wrote about Lord Halsbury as the longest serving Lord Chancellor since Eldon. And he said about him, quote, "There is perhaps in his later judgments too frequent an appeal to the merits of that common sense which is characterized by the approving epithet sturdy." But Houston does not condemn the common sense itself, or, and he was writing before proportionality, the idea of standing back and looking at a proposed judicial outcome in the full context and examining it in that way, and not as a purely legal point. But the controversy that arose is that proportionality enabled the judges in the UK to sometimes find decisions they didn't like disproportionate to the upset of government, to move, and forgive me if I'm presuming there's some lawyers here, to move from the principles in which we were taught of judicial review by Lord Green in the Wednesbury case, which were concentrated on whether the process was a lawful and fair process, into the judge simply deciding that he thought the minister's decision was disproportionate. And that is bound to come under more detailed scrutiny in a post-EU world, both in Northern Ireland and in the rest of the United Kingdom. And another illustration of that is that in the human rights field, the courts moved from the Wednesbury principles towards heightened scrutiny. Well, there's good juridical basis for that, but again, of course, it gave the judges more power than they previously chose to exercise, to the annoyance of the United Kingdom government. Sometimes I feared, listening to her, that Prime Minister May confused in her own mind the European Court of Justice at Luxembourg with the European Court of Human Rights at Strasbourg, and thought that they were one and the same thing. The United Kingdom continues to subscribe, at least at present, to the European Convention on Human Rights, but it is sensitive to its decision. Prime Minister Johnson was said to be furious at the decisions of the courts, which he felt were anti-Brexit in the lead up to the final conclusion of that saga. It may be that his hostility to court decisions has been somewhat lessened by the decision of the Court of Appeal in England to condemn the approval of the third runway at Heathrow Airport. This was a decision of the gentleman rather cruelly named as Failing Grayling, who was actually Lord Chancellor at one point, and then as Transport Secretary, in the view of the court, failed to take into account the Paris Accords on climate change in allowing the third runway. And Johnson, as you'll recall, is a West London MP, and he was vehemently opposed to this, saying he would lie down in front of the bulldozers, which is yet to do. So this decision has got him off that hook, so that might alter what is otherwise said to be his intention to restrain the powers of the judges. Because in conclusion, a strange thing happened. The Lord Chancellor of England, right up until 2007, personally selected the senior judges. There was a commission, there were recommendations, there were consultations, but at the end of the day, the last, Lord Irvine, Lord Faulkner, were still saying, actually, no, we won't have him, and yes, we'll move down the list and have him. And Gordon Brown didn't like either of the Blairite candidates to be Lord Chancellor. Lord Faulkner and Lord Goldsmith, they're both in their different ways very able men. And he brought in Jack Straw, who'd been a barrister briefly in his youth, And Jack Straw was presented with the list and said, well, how do I know how to finalize these appointments? And said, we'll have to have panels. So what had already been a divergence in the British system between politics and the judiciary, where it was unfashionable for judges to have been MPs or to have any role in politics, was exacerbated by handing that over to panels with judges on them. Now, I believe that another ex-officer of the Society, Shane Ross, who was defeated for the auditorship by Ian Ash here 50 years ago, I know he's been exercising this, and I won't tread in any toes here, but in England they have a genuine problem, which has exacerbated the Brexit thing, that there's a complete divergence between the judiciary, which are in danger of being in an ivory tower, and the politicians who sometimes feel that the judges have no experience of public life or about the needs of politics. So that the future of the common law post-Brexit may well sound in those areas as well as in a number of the interesting and acute observations that the Chief Justice has given us. So I want to conclude my remarks and conclude this evening's proceedings with thanks to the Chief Justice for his remarks. Thanks in two ways. One, a signal honour to present to you the first copy, hot off the press, of the new history of the College Historical Society. Delivered by the publisher himself, and you've anticipated the second measure of thanks by a warm round of applause. Thank you very much.